afternoon, Chancellor, my lords. I was going to take the court to the diagram. Before I do so, please, we need to look at what the parties said about the diagram, which is at paragraph 4.6 in the bundle. Sorry, paragraph 4.6 in Schedule 1, which is page 532 of the bundle.
Yep.
It provides as an illustrative example of the manner in which the call options are intended to work. The parties have prepared the diagram set out in Part B below. So we say that the diagram reflects the parties' contractual intention, it says so expressly, and it reflects the fact that they have turned their minds to the diagram. It says so again in terms. Now, the learned judge, I don't think we need to turn it up, but the learned judge in paragraph 366 of her judgment observed that there is no evidence or submissions before the court to the effect that the diagram in this case deserves particular attention as something to which the parties particularly turn their minds. And the learned judge was there quoting from a judgment of Mr. Justice Blair in the Starbev case. Well, we say, with great respect to the judge, that's not correct, because it's clear from paragraph 4.6 on its face that it is something which the parties have turned their minds to and prepared, and that's why they've included that wording in paragraph 4.6. My lords, two authorities very briefly on the relevance of such diagrams, if I may. The first is that judgment of Mr. Justice Blair in Starbev. That's in the authorities bundle at tab 12, page 276. And then if one turns to page 339 in the bundle, and if I might ask my lords to read paragraphs 283 to 285 on page 339.
Yep.
So, my lords, we rely upon that for two propositions. The first is that it should be treated just as much as being an express term like any other in the contract, and the second is it may deserve particular attention as something to which the parties have particularly turned their minds.
Yep.
And we say that's true in this case where the regime in respect of how the options are to be exercised is a complicated one due to the complex interlocking provisions earlier in the contract.
Yep.
The next authority, or the other authority we rely upon in this regard, is at tab 17, page 422. A relatively recent decision of Mr. Richard Salter, then Queen's Counsel, in a case called Altera Voyager Productions Limited and Premier Oil EP. If I might ask the court, please, to turn to page 446 and to read paragraphs 74 and 75.
Yep.
And so we say that in this case, it is actually one in which when the narratives and formulae are worked through in the diagram, their true effect can properly be seen. We don't suggest that the diagram trumps other provisions in Schedule 1. On the contrary, we say it is consistent with those provisions and it illustrates clearly how they are supposed to apply. If we might now turn to the diagram. Now, my lords may have appreciated there are two versions in the bundles. There is one which is immediately behind Schedule 1, but there is also one which may be of more...
One that's behind tab B.
So I apologise, my lord.
There's a legible one that's right at the back of the bundle.
Yes, there is, my lord. There's a legible one there. In fact, you're quite right, my lord, of course. It appears 3 times in the bundle. So there's the legible one here. But also for the court's assistance, we have a marked up version, which is in the supplemental bundle at page 263, tab 31. Page 263 in a supplemental bundle. Now this is the marked up one is one which we prepared and provided to the court below for the purposes of this part of the case. The red text is all text which has been added by my side, those instructing me. And likewise the red boxes. The reasons for the red boxes is to highlight in particular important questions for the purposes of the application of the flow chart in this case, and the text in red highlights where the relevant provision is found in Schedule 1. So we've essentially added in some references to the worked example which otherwise appears in Part B. As I say, this is provided below. No dispute has been taken by JP Morgan that this is an accurate depiction, as I understand it. We rely here on this page on the question, which is in fact the first question that has to be asked, and that appears in the box in the middle of the page, the red box in the middle of the page to the left of the blue one. The blue one is a starting point, call option fair market value established by valuation experts at each measurement date. So that's the valuation exercise. And then the first question that has to be asked on each occasion is prior to the 4th measurement date and JPM has a call option remaining. And our point is this, that question, prior to 4th measurement date and JPM has a call option remaining, is a question which is impossible to ask on the multi-shot construction. It is impossible to ask on the multi-shot construction because we know from paragraph 2.3 that JP Morgan has the opportunity to exercise its call option in each of the call option exercise periods. Unless WL has already bought the shares, but if WL has already bought the shares, then we're not in this situation anyway. We've never got out of the blue box because one is not having a call option fair market value established by valuation experts at each measurement date. Before the process has ended, the shares have been bought. Contrast to the one-shot construction, the question whether JPM has a call option remaining is an essential question to ask because one is asking, on a previous occasion, has JPM sent a call option exercise notice? If JPM has sent a call option exercise notice, then it doesn't have a call option remaining as per the proviso to paragraph 2.3.
How does it work if you're wrong about that? Suppose the judge is right and the option's non-exercised unless and until there's a binding contract for sale. And there hasn't been so far. You then answer the question, yes, JPL does have a call option remaining because it hasn't exercised it on the judge's interpretation. And then how does this flow chart work?
On that footing, then one goes up to on the diagram, takes the up arrow. JP Morgan has a call option remaining.
Currently measuring at 4th measurement date.
Yes, and so then we ask there yes or no. If you're at the 4th measurement date, then the position is WRL does not have an opportunity to.
But what it doesn't do is tell us what happens at the 2nd or the 3rd, in the 2nd or the 3rd auction period. Assume the judge's construction of exercise is right, so that in the 1st auction period JPM serves a notice but that doesn't result in a binding contract for shares. This diagram doesn't help us, does it, on the 2nd or the 3rd period?
think, my lord, it does, because I think that one asks a question currently measuring at the fourth measurement date, and if one gets the answer no, then that means one is measuring at an earlier measurement date. You're not currently measuring at the fourth measurement date, answer no, then you have the question whether the call option price is greater than or equal to the reference valuation. That is a question which is relevant before the fourth measurement date.
Only relevant on the first, second and third.
Yes, indeed, my Lord Chancellor. But it wouldn't be relevant on the fourth measurement date, because if at the fourth measurement date the reference valuation disappears, the floor disappears.
Precisely. So we go JPM call option greater than or equal to reference valuation, no.
Yes.
JPM exercises call option.
And then if we're prior to the fourth measurement date, WRL has an opportunity to reject the call option exercise, which is what is reflected in.
Is that in the box?
Yes. So if we have JPM call option price greater than or equal to reference valuation, we say no. So it's a not. And then JPM exercises its call option, so it's exercising its call option at less than €5 billion. And then, if it does, then the question becomes: does WRL agree to sell? If WRL doesn't agree to sell, then no, we get defer to next option exercise date.
Well, isn't that consistent with the multi-shot?
No.
Because the exercise is now deferred to the next option exercise date?
It's not, my lord, and this is a point in which, with respect, we say that the judge fell into error below, because option exercise date means WRL option exercise date or JPM option exercise date as applicable. And so here, as applicable, it's the WRL option exercise date, not the JP Morgan one. Option exercise date is a defined term.
Yes, I know.
Yes.
Why can't it mean the next JPM option exercise date?
Because as applicable means you choose the correct one, and here the correct one is WRL option exercise date.
Only if the judge is wrong. That's why it doesn't really help, does it?
Well, it does, my lord. We say, because one has to. Well, first of all, the question we say doesn't arise on the multi-shot construction. You don't ask the question whether JP Morgan has a call option remaining.
Well, that depends on whether it's exercised one of its previous options, and the judge says no, you don't exercise it unless the service of the notice results in the creation of a binding contract.
But my lord, the question only has relevance. We're only in this option exercise scenario if the shares haven't already been bought.
I understand that.
So we say for that reason that it doesn't arise, because one simply doesn't get out of the blue box. You're not there. And then if one gets to the end, when one says look at the next option exercise date, what one is referring to is the next option exercise date as applicable, and that's the WRL option exercise date, because the JP Morgan option exercise date has fallen away. So we say that is consistent, but it is a point that the learned judge made below, but we say is answered by the definition of option exercise date.
Well, in a sense that that's made good by the upper reference to defer to next option exercise date, which can only be the WR one, can't it? Well, I suppose it could be both. It could be multi-option.
Yes. So, my lord, in respect of these, we say that the answer when it says option exercise date is you go back to the definition and you choose what's applicable, and here it has to be JP Morgan. WRL option exercise date. Now, my lord, if we look following through the diagram, what happens if JP Morgan doesn't have a call option remaining? This is in the area which has been marked on the diagram as A. That was in the original text. We see if JP Morgan doesn't have a call option remaining, the answer is no. We then go down to the next red box, which reads WRL exercises WRL call option. If WRL does so, then we go up. Yes, we're in paragraph 4.2, which we looked at before, deals with the transfer agreement. No, WR doesn't exercise the call option, we then kicked out into clause 15.1 and what is the Schedule 2 strategic review scenario, and that essentially deals with options for the parties to agree how they're going to go forward, whether by an IPO, whether one buying or selling shares, but it's outside of the Schedule 1 call option regime. So we say that is, again, that's consistent with how we say the one-shot construction works, and that's how it would proceed. Now, the learned judge...
Can I just, in the first red box on the left, that you encounter on the left, prior to fourth measurement date and JPM has a call option remaining, you say that can only apply to the fourth measurement, sorry, to the fourth option period, or are you saying it could apply to any option period?
So it can apply to any option period.
That's what I thought you said. So if the answer is yes, and you go up, the question then becomes currently measuring at fourth measurement date. Suppose you're in the second option period. How do you answer this next question?
The answer is no, you're not currently measuring at the fourth
It's frightfully
measurement date.
complicated, but what that's contemplating is that this is being looked at the fourth measurement date, which is inconsistent with the previous box.
Yeah, that's what
I mean, that's currently measuring at fourth measurement date. Can't understand if it says no, because then you're into the fact that WRL has the ability to refuse to accept in certain circumstances.
Yes.
Whereas if it's yes, then JPM has a right, an untrammeled right to exercise the option if they choose to.
Yeah, yes, my lords, we accept there is an inconsistency between that red box, the first red box there, to the.
And then if you go into the next one, it says JPM exercises JPM call option. Answer yes, well then you get into the next sheet, which is the one that explains what happens when the option's been exercised and accepted, when appropriate. But if it's no, then you say move to point A. And point A is the Schedule 2 Clause 15 scenario, isn't it?
Well, we first move to point A and we get WRL.
Well,
yes,
WRL then has a right to exercise its option. If it says no, then you get
then we're to Schedule 2. Yes. Now, we recognise that there is an inconsistency here, which is that there's a question in the red box prior to fourth measurement date, and then the next question is currently measuring at fourth measurement date. The answer to that, we say, is that the words prior to fourth measurement date are not the important words in this question. The important words in the question are JPM has a call option remaining. That's the question which has to be asked. And that fundamental question is just not a question which can be asked, we say, on or sensibly asked on the multi-shot construction. What the learned judge did was take a rather different approach and if I may summarise, it's paragraphs 377 and 378 of the judgment.
Well, I suppose it's prior to fourth measurement date. Doesn't mean the same thing as at third measurement date. So this is just looking at the situation immediately prior to fourth measurement date.
Yes.
Asking the question, is there a call option remaining? Answer no. Then you go into WRL being able to exercise its option. Or answer yes. And then obviously it will be measured at the fourth measurement date.
Yes.
Because by definition, that's where you are.
Yes, my lord. There could be a temporal shift between that box and the box above. Yes, and it's not very elegant.
No.
We would acknowledge, but we say, with respect to the great respect to the learned judge below, she simply does not deal in her judgment with the central question, which is why have the draftspeople put JPM has a call option remaining if it's not a relevant question. What the learned judge does in paragraphs 377 and 378 of the judgment is say that there is a composite question. And she says there's a composite question which has to be asked, which is coming from that prior to the fourth measurement date box, and JPM has a call option remaining. The learned judge says that read in this way, in the circumstances where JPM has not exercised its call option in the fourth option exercise period, the answer to step 2 would be no, because it was not prior to the fourth measurement date, and JPM does not have a call option remaining because it is terminated, consistent with paragraph 2.4. 2.4 only arises in the circumstance in which WRL has already bought the shares, so we're just not in this territory at all. So the fundamental problem here is this is an inexplicable question on the multi-shot construction, we say, and that is a very important pointer towards what is the correct construction. And there's no solution to say that it should be read as a composite question, as the judge seeks to do, because the composite question is with respect by the by. The composite question is seeking to read out why the parties have decided that you should ask the question JPM has a call option remaining. Then the other point in relation to the diagram is this, and it's on the next page, and if my lords are in the marked up version, I apologise because of the page 2 is only in the core bundle at page 618. Page 618, the question which is asked is, after JPM exercises the JPM call option, or WRL exercises the WRL call option, and in the case of JPM exercising the JPM call option, WRL agrees to sell. Well, the difficulty here is that on the multi-shot construction, this question can't be asked. Because on the multi-shot construction, one doesn't ask about JPM exercising a call option and WRL agreeing to sell. It's the point which we made in relation to the distinction drawn in the body of the contract, but as per Mr. Salter, Queen's Counsel as he then was in Altera, as per Mr. Justice Blair in Starbev, this is setting out rather starkly how it's supposed to work, which one might not have gleaned necessarily from first reading through the relevant provisions. So we say, again, this is something which is inexplicable on the multi-shot construction. Once one works through the diagram, one can see the true effect, and the true effect is that exercise must mean sending the option exercise notice. Now,
well, what it demonstrates, you would say, is that exercise of the option is quite distinct from acceptance or agreement.
Indeed.
From WRL's point, let alone the actual transaction to sell.
Indeed, my lord.
Transfer.
Indeed, and we say that the regime that the parties have agreed is that JP Morgan gets the opportunity to go first by sending its option exercise notice. WRL has the opportunity to veto it, but only if it is below the reference valuation, and if so, WRL then gets its turn. We say that's the commercial bargain that they've struck. Now, my lord, the final point to deal with is commercial common sense, and I appreciate that my lords may well have felt you've heard too much about commercial common sense over the past 3 days. So hopefully I can keep it brief. We say two things. One is the one-shot construction is consistent with business common sense or commercial common sense. But secondly, we accept and we aver that business common sense has no real role to play on this construction issue, the choice between the one-shot construction and the multi-shot construction. We say that this is just a matter of pure textual construction, having regard to the different provisions. And we say that on the one-shot construction, we're not doing violence to the original text. We're consistent with the original text. And we say this is one aspect of the learned judge's judgment where the learned judge departed from the original text, and she acknowledged twice in the course of her judgment on the one-shot issue that it would be surprising if parties such as these in a sophisticated commercial contract were seeking to use the word exercise to use different things in the same paragraph. And the learned judge found that they were doing it twice, but nevertheless she reached her conclusion. Why we say the one-shot construction is consistent with business common sense? Well, it means, in short, that WRL retains control of its own contractual destiny, provided that the floor valuation of 5 billion euros is not met. That is a perfectly coherent commercial justification. If the call option fair market value hits the reference valuation, hits the floor valuation, JP Morgan can buy WRL out against WRL's will. If, however, the call option fair market value does not meet the figure, then JP Morgan may make an offer to buy WRL out, but WRL can accept it or reject it. It retains its own destiny, retains control of its own destiny. It can choose whether to be a buyer or a seller, or whether to proceed to an alternative exit scenario under Schedule 2. The other point we make in respect of commercial common sense is that the multi-shot construction is, we say, a strikingly unusual arrangement, because what it enables JP Morgan to do rather, is to block WRL consistently for 4 option exercise periods. And in a contract which by paragraphs 2.1 and 2.2 said the parties are being granted respective call options in consideration for each other, JP Morgan grants WRL a call option, WRL grants JP Morgan a call option, it is clear that unless the reference valuation of 5 billion euros is hit, WRL can never exercise its call option. It is strikingly asymmetric, and it is a very unusual situation. It could have unusual commercial consequences. One commercial consequence is if the value of the company, the group, did not appear to be exceeding 5 billion euros, then it would be the interests of JP Morgan thereafter for the 4 option exercise periods either to constrain the growth of Viva for the period of the option exercise, or at least it would have an incentive to drive down the valuation of Viva for the commercial option exercise periods, because at the end, the 4th option exercise period, it would be able to exercise its rights to buy at whatever the ultimate price was. Now, I don't want to put it too highly, but it is striking. It would allow a party to have a commercial incentive for a short-term potential loss, which is to say that you would be constraining the growth of the company for a period of 2 years. The outcome would be you get to buy it at that ultimate market value. Now, that's unusual in circumstances where this is, to all intents and purposes, a joint venture until the call options are exercised. The parties are supposed to be growing a company, and it says so expressly in terms in the contract, that the parties are supposed to be growing a company in order to expand, and we saw that even to expand into the United States. So it's unusual to have a multi-shot construction, which arbitrary figure, 5 billion euros, if it doesn't hit that, JP Morgan then has an incentive that the value of the company should be lower. But we say our second point is that business common sense here is not determinative. We say it's not determinative because firstly, this is a sophisticated commercial contract. The parties have not only drafted these provisions and can be expected to have focused upon them, but they provided a diagram that expressly says how they are intended to work. I read out before a section from the Palladian decision, and Lord Justice Popplewell, paragraph 59, Lord Justice Popplewell said, in this context, a court should be wary of assuming that it knows what is or is not commercially sensible, where the language used points to a clear answer, as my Lord Justice Lewison observed in a case called Napier Park, European Credit Opportunities Fund Limited versus Harbour Master Pro Rata, CLO 2BV. Parties who have chosen clear language in which to express their bargain can be assumed to understand the commercial and economic context, and can usually be assumed to have intended the result, and therefore ex hypothesi not to have regarded it as one which has no commercial or economic rationale. We pray that in aid, the parties have plainly considered these provisions, and this is the conclusion they've come to.
Yeah.
And we, with the greatest respect, urge upon the court not to second guess that commercial rationale. And we do so in particular because one has to look at this situation at the time at which the parties entered into the SHA. And at the time which they entered into the SHA, the parties do not know whether they are going to be a buyer, whether they're going to be a seller, whether they're going to want to have an IPO under Schedule 2. Those things will depend upon, importantly, the growth of the company, the market at the time at which the options are being exercised, and the party's own funding position and own interests in the business as developed, how it has grown. And so we say that one cannot proceed on the assumption that JP Morgan would wish to exercise its option, or that WRL would wish to exercise its option. One has to simply say the position is the parties have created a regime which gives them both opportunities to exercise their call options at the price at which it may be deemed to be the market value by the valuers at that time. In paragraph 401 of her judgment, the learned judge said, insofar as JPM held off from exercising its call option, it would also put JPM at risk of WRL exercising its call option without any protection as to the level achieved. Well, and relied upon that as a matter of common sense. Well, we say, my lords, the question about whether a party exercises its call option or not is a classic example of an economic choice which they're going to take. It cannot assist in the construction of these provisions, and in any event, it is simply incorrect to be, with the greatest respect to the judge, to be using a terminology such as without any protection as to the level achieved. The regime the parties have agreed is that ultimately there's going to be an assessment of call option fair market value by 2 or 3 experts. And so as a consequence, there are so many unknowns and variables, we say that the correct approach to construction is to look at which construction is most consistent with the express terms. We say the construction that is consistent with the express terms is the one-shot construction and not the multi-shot construction. My lords, may I just turn my back briefly? My lords, those are the submissions I wish to make in opening.
Can I ask you 2 questions? Mr.
Yes, of course.
The judge placed quite a lot of reliance on the fact that in ordinary legal language, an option, when exercised, gives you the right to acquire an asset.
Yes.
And she says that at 326 and 327 of the judgment. In effect, we all know what an option is. An option means that when you exercise it, you've got a right to acquire the property.
Yeah.
In this case, serving the notice doesn't confer that right.
Yes.
So we've got to interpret the language of Schedule 1 consistently with what's described as an option.
Yes.
What do you say to that?
We say that, we would say 2 things with respect, my lord. We say, first of all, the options are carefully defined here. They are not some sort of term of art that one might understand option to mean absolute right to buy. On the contrary, if one looks at paragraphs 2.1 and 2.2, one can see that the parties have been quite careful in how they refer to these options. Paragraph 2.1, page 523. In consideration of the grant by JPM of the option in paragraph 2.2 below, WRL grants to JPM an option to purchase WRL company shares for the exit proceeds on the terms set out in this Schedule 1. On the terms set out in this Schedule 1 is, we say, essential and not accidental. Same is provided in 2.2. Again, the WRL option is granted by JPM on the terms set out in this Schedule 1. The other point we make in this regard is that the parties have chosen in 2.3, 2.12 and 2.5 as regards the JPM call option to identify how they say the call option is exercised. And we say if the parties choose to do that, then they can hardly be expected to be falling back to some generic meaning of option as being an absolute right to buy.
Well, they may just have labelled it wrongly. They may just have labelled the rights wrongly.
In 2.3, 2.5 and 2.12.
In calling it an option.
And indeed, my lord, absolutely.
It's the wrong label.
Absolutely, my lord. That's actually what that's what we would say. We would say that what the parties have created here is a regime in which they may or may not be able to purchase the shares of each other But what they've not done is plainly not created an absolute right to buy.
Yeah.
So if one understands option to mean absolute right to buy, then it's the wrong language. And we can see that even on the multi-shot construction, it's the wrong language, because if WRL has been granted an option which, on the multi-shot construction, it could never exercise if the reference valuation is not hit.
Yeah.
Sorry, if it can, it could never exercise, irrespective of the reference valuation, by dint of JP Morgan just either offering or blocking.
My second question is whether there's any light to be shed on the issues that we have to determine by Schedule 8 to the shareholders agreement, which begins on page 563. Now, I haven't gone into this in enormous detail, but this seems to give an option to what's called a non-defaulting shareholder to buy out a defaulting shareholder. But the point for present purposes is that it works in two stages. First of all, you serve what's called an option to purchase notice, and that sets in motion a mechanism for determining the price. Once that's been determined, stage 2 is the service of a right to purchase notice, and that is that second notice which brings the contract into being. Now, in Schedule 1, we only have one notice. We've only got provision of one notice.
Yes.
And I wondered whether any light was shed on what that notice is supposed to do by the two-step procedure which the parties have agreed in Schedule 8.
Well, my lord, my immediate response is Schedule 8 cannot be read across to Schedule 1 because the parties have used quite different terminology. In Schedule 1, I think it's exercise notice which is used. Here, they've used defined terms as option to purchase notice and right to purchase notice.
But they have catered for a situation where the mere service of the notice doesn't necessarily result in a contract.
Indeed,
You've got
indeed.
to do something else.
Indeed, and that would be consistent with what we say, which is that it's not snap, that there's a distinction drawn between the two. But what we say, for example, the judge says holds accurately. She says, well, in the main body of the contract in clause 15.1, that must be understood to be exercised in relation to the exercise of the substantive right to buy shares, and we accept that's right as clause 15.1 goes. But what one is looking at here is the regime, which a particular regime the parties have created in Schedule 1, which flows right from 2.1 at the beginning, where they set out that these are particular terms on which these options can be exercised. So our primary submission is Schedule 1 is a self-contained environment. It's hermetically sealed, and it has to stand or fall on Schedule 1.
It's really dealing with defaulting shareholders in the sense of insolvent. I think it's where there's a material default.
Yes.
And actually, it's the company that serves the notice. So
yes.
Under Schedule 8, the company serves a notice on the non-defaulting shareholder, which gives the non-defaulting, which is an irrevocable offer.
Yes.
To transfer the shares at a certain price.
Yes.
So it may be that it's also being described as an option. Yes. Perhaps more accurately in that case as an option. But it's a different sort of option on any view to the one that we're concerned with.
My lord, we would respectfully agree with that, and we would respectfully agree with it and rely upon it as indicating that one should not invest too much weight. In fact, we would say not put very much weight at all on what might be deemed to be a conventional meaning or a usual meaning of the term option. We say that one has to look at what the contract civilly provides. My lords, unless I can assist further, those were my submissions in relation to Schedule 1.
Yes.
Lords, can I just start by picking up on one of the last points that Mr. Weeks made, which was in relation to the Palladium case, and when he was dealing with business common sense, he said, well, this is a case where you need to concern yourself with business common sense because the words of the schedule are so clear. And we say that that submission is clearly unsustainable, not least because this was an argument which emerged on the eve of the trial. And before that, both parties were proceeding on the basis that the multi-shot construction was correct. And this seems to have been an idea which was thought up by WRL's US law expert in his reply report. And it resulted in an application to amend brought the night before the trial started. And as I say, until then, both parties proceeded on the basis of the multi-shot construction, and we see that from Mr. East's evidence which accompanied the Part 8 claim. And in view of time, I'm not going to go to it now. If I have time, I'll go to it later. But the important point is this. In circumstances where both parties have been proceeding on the basis that multi-shot is correct, it is an ambitious submission to say that the words are so clearly the other way that you should ignore business common sense. And I'll come back to business common sense, but I wanted to start with that point. Now, when we look at the provisions of the shareholders agreement, we respectfully agree with the formulation of Lord Justice Lewison that the key question is essentially what the word exercise means within paragraph 2.3 of Schedule 1. And we say that the word exercise in that paragraph, as it is in other key places in the contract, must be construed not only as sending the notice, but the sending of a notice which results in a binding obligation to sell. I'm going to try and avoid using the word a binding contract to sell, because then we get into questions about the Chancellor agreement and so on, which, as we've seen, is a separate step. But the sending of a notice which results in a binding obligation to sell. So not just an action, but an action with a consequence. And as you correctly identified, that's the, in a nutshell, is the issue between us. Now, much has been made by WRL as to the fact that JPM's construction requires the word exercise to be read in different ways in different places in the agreement. But the truth is that, in fact, there is not a single use of the word exercise on either party's case that can be applied consistently throughout the agreement. And as my Lord Justice Lewison just identified, ordinarily when one talks about exercising an option, one means an exercise which does result in an obligation to sell. That's what a call option is. You have the right to call for the shares. And that's the natural meaning, we say, of the word exercise, and that's the way it's used in 2.3. And before we look at that, can I just show you clause 15.1 of the contract, because we've seen it on the diagram. It's page 495 of the core bundle. So we've seen this on the diagram, but you haven't been taken to it. Now, the 30-month period over which the options can be exercised is known in the contract as the lock-in period. And this clause 15 deals with what happens afterwards. And clause 15 says this: if no call option has been exercised during the lock-in period in accordance with the terms of this agreement, and no other circumstances exist which have resulted in one shareholder holding all of the shares in accordance with the terms of the agreement, then the parties enter the strategic review period. So, and that, the rest of the clause tells you what that is. The parties have good faith discussions as to how to exit the relationship. And then 15.2, at the end of the strategic review period, which takes 6 months, then the parties automatically enter into the post-lock-in period. And then we've got Schedule 2, which you haven't seen, but that's things like right of first offer, drag-along, tag-along rights, and so on. So that's the structure. But the important point is at the beginning of 15.1. You only enter the strategic review period if a call option has not been exercised. In other words, what's clearly meant there by the word exercise is a one in which one party has ended up holding all the shares.
Which would include Schedule 8, in fact, wouldn't it? the Schedule 8 would be another circumstance which has resulted in one shareholder holding all the shares. Because the other one's in default.
Yes, that must be right. But the first part of the sentence is talking about,
But this is, that's a point that's in your favour.
yeah. No, I see that, I just didn't want to agree too readily.
If no call option has been exercised and no other circumstances exist, so in other words, the call option has been exercised is predicated upon it's resulted in the shareholder holding all the shares.
Yes. Yes, exactly. And call option is a defined term which sends you straight to Schedule 1. So that's a clear reference to Schedule 1. And we've seen it on the diagram, as you see. So while we're here, it's just worth casting up the page to clause 15, because a similar point can be made there. That's about the share option
Clause 14.
plan. Clause 14.2c. So this is the share option plan, which is to be put in place on or as soon as possible after closing for employees and so on. Now, they can only exercise their call option, their new share options, subparagraph C, in the event of an exit or exercise of the JPM call option. So again, it can't be right to suggest that an employee's right to take advantage of its share options should be affected by whether or not JPM has simply sent a notice. So that must mean action plus consequence. So starting point is an option is a right to call for the shares, and the exercise of an option means.
Sorry,
Sorry.
what is the new share option plan?
Sorry, it is 14.1.
This is issuing additional shares to employees, is it?
Yes, it's well. There is the shareholders envisage that on closing, or as soon as possible after closing, the company Viva would put in place a new share option plan for employees. 14.2, they have to discuss and agree in line with the following principles, and then one of the principles is that the participants can only exercise their options.
It says
Those
that options over up to 43,467 shares may be granted.
Yeah.
Those are new shares, are they?
Yes. Sorry, the point I was making was that the trigger, those are different options. The point I'm only making is that those options may only become realised by the employees on exercise of the JPM call option.
On your construction, exercise of the JPM call option means that JPM owns all the shares in the company.
Yes.
So these 43,000 odd shares are new shares, are they?
Yes.
To be issued after JPM has acquired all the WRL shares.
Yes. So you agree on the plan, and it sits there, but the rights only then accrue to the employees at the point at which JPM acquires all the shares in the company. So the point I'm making is simply that exercise of the JPM call option must mean action plus consequence, because otherwise it can't be right that people get their shares, their granted shares, simply because JPM has sent a notice which has been rejected.
What does 14.2e mean? I mean,
Yeah.
is that in your favour as well, or
Yeah.
It would be? How does it work? On the one-shot example, just by serving the notice, this right, all JPM can simply make all options best lapse or roll over. Whereas you say no, it must mean only where there's exercise plus consequence, only where serving the notice plus consequence.
Where JPM becomes the owner.
Yeah, because it's only in that circumstance it'd have the interest to decide how,
Right.
what happens to the share and indeed to provide replacement options.
Yeah.
Because otherwise it just serves a notice and then it's supposed to decide in some way what's to happen to all the share options irrespective of whether there's any consequence.
Yeah.
Which, yeah.
So exercising the option clearly in these parts of the agreement must mean action plus consequence, and I'm not sure that's even disputed. I think WRL's response is, well, you just look at Schedule 1 and you can just, if you just look at Schedule 1, then exercise can simply mean just send a notice. But the point I'm starting with is that there isn't a single, that construction, exercise simply meaning send a notice, cannot be applied consistently throughout this agreement. So to some extent, you are having to pick and choose between them. And ultimately, the question which the judge addressed was, well, what does it mean in 2.3? So, just picking up on a point that was raised at the end, we don't accept that this bundle of rights is wrongly labelled an option. It is an option, but it is an option that is itself optional in certain limited circumstances. That is to say, the first 3 option periods. And there are certain conditions, as you've seen, which apply. So WRL is not obliged to accept that option in those first 3 periods, and so it means the most that JPM can do in those first 3 periods is attempt or elect to exercise the option by sending the notice. Now,
Well, that's not true, is it? Because JPM could specify the price which assumes a open market value of more than 5 billion, if that's what it wanted to do.
you can't just,
Could do.
I don't think it can just specify that. I think it's bound by what the experts determine to be the call option fair market value. There is a possibility for it to offer a bit more. I don't think it can just, in order to exercise the option, I think that's right, I'd be corrected if I'm wrong, but it has to take the value that the experts come up with, because of course it's the same value whether it's JPM exercising the option or if WRL get the chance to, so that's the single value. So it can't make itself an enforceable option by designating a price of 5 billion euros if the experts have only come up with 1 billion.
Well, that's because clause 3.1 says the call option fair market value of the shares is to be valued for the purposes of this schedule, as determined by an expert in accordance with paragraph 3.
Yeah.
So the relevant fair market value is determined by the expert.
Yeah.
So you can't, as it were, ace the expert by saying, "Oh, I'll pay you 5 million."
No.
Well, this is less because they agreed with an amendment.
You could do it outside of the option process if you wanted to, outside the shareholders agreement. But the point I was making is that because there is this conditionality in the first 3 periods, all that JPM can do in those, it may be that all they can do is attempt to exercise the option by sending a notice or elect to exercise. And we agree that Schedule 1 does draw a distinction between, in some circumstances, between electing to exercise, in other words, sending the notice, kicking off the process, and its acceptance and the consequences. And often when it means that, it does say elect to exercise, as in the chapeau of 2.3, which I'll show you in a moment. But sometimes they have used imprecise language and slipped into shorthand and used the word exercise in a couple of limited places relied on by WRL. They say exercise when actually all they mean is elect to exercise. But it doesn't mean that the tail wags the dog, to coin a phrase, and you assume that in every instance where the word exercised is used, you are simply meaning send a notice, because that's not the natural meaning that one associates with exercising an option. So can we look at 2.3 then? So the way it was put just now is that the answer to the whole question is in the chapeau of 2.3, which says JPM may elect to exercise. Well, we say no, because that's an example. The words elect to exercise mean electing to exercise by sending a notice, as it says. Now, and those words, elect to exercise, indicate something different from actually exercising the option in terms of action plus consequence. And it doesn't, the reference to the word election also does not mean that JPM can only do it once. And in fact, the judge made this point at paragraph 323 of the judgment by reference to the word times in the first line. So times is plural, which does support the multi-shot, because it suggests that it may elect to exercise its option in at the following, any one of the following times. Now, if we move on to the proviso, what the judge found, we say correctly, is that the word exercise here does mean action plus consequence. And so what we have here is a single compendious proviso dealing with both JPM and WRL potentially exercising their option. And it's very clear, as far as WRL are concerned, that when they exercise their option, that does result in a binding obligation to sell. And therefore, it's only that will prevent the exercise of the JPM call option in the following option period. So she said correctly that the same must be true of when JPM exercises an option for the purposes of this proviso. And it follows that the right way to read exercise is exercise resulting in a binding obligation to sell. So in JPM's case, on the one-shot construction, you have this single compendious proviso. You're looking at what happens when both parties exercise their option. But on the one-shot construction, the mere action of sending the notice engages the proviso. And on the, in relation to JPM only, but in relation to WRL, the shares actually have to be bought to engage the proviso. So it's an odd way, we say. This is the foundation of the one-shot argument. That is a very odd and convoluted way to go about putting in place the one-shot argument, if that's what you intend to do. A single compendious proviso with different consequences. And the Chancellor asked the question, well, what is the point of this proviso if multi-shot is correct? Because if JPM has previously exercised its option and the parties are proceeding to a contract, why would you ever need to have that there? And the answer is that it gives certainty to the parties, because we've looked at 4.2, but if we just turn that back up again, page 531, now, the call option is this is on the basis that the call option has been exercised and the parties are then proceeding to enter into an agreement. And the important words are in the penultimate line, following of the chapeau, following satisfaction of any mandatory consents required for the transfer, the following shall apply. Now, the mandatory consents are the consents that have to be obtained under applicable law. That's page 602 of the agreement in the definitions section. And that may take some time, because there's no unsurprisingly, there's no time in which that is to happen because you're dependent on whoever it is, the third parties. That may take some time, and it may actually not come. In which case, the point of the proviso stops. Assuming an option notice has been sent, it's been accepted on JPM's exercise of the option, then time ticks by, the mandatory consents aren't obtained in time for the next option period. It then stops another party coming back in the subsequent option period and saying, well, we're going to, as that one hasn't worked, we're now going to have another go, as it were, with a different valuation. And of course, the relevant option periods are defined essentially by reference to calendar dates. So they have a sort of independent existence.
Sorry, can you just rewind that last little bit?
Yeah.
You say in the provisos under B, C, D and E.
Mm-hmm.
Proviso means provided that the call option has, provided that neither call option has been taken through to the entry into a transfer agreement or the completion of the transfer.
No.
I've lost the thread of your argument there.
I'm so sorry.
It's me.
I'm not saying that in order to exercise the option you have to go through to the transfer agreement. I'm saying it is because you've got this conditionality built into the first three option periods. Yeah. It is the sending of the notice and, if necessary, the acceptance, or you're over the 5 billion. You're over the €5 billion valuation. In other words, you've got to a position where WRL must sell, subject to what's in 4.2.
I'm not sure that I've quite understood this. You're making a point about mandatory consents, and there's some sort of regulatory consent, I assume.
Yeah.
So, take the first option period. There's no proviso to that one.
Yeah.
JPM serves a notice. WRL accept it. You go off for mandatory consents. It's taking a long time to get them, at which point the second option period starts. Has JPM exercised its option in the first period or not?
Yes.
Even though they've still got to wait for mandatory consents?
Yes, it has exercised its option.
Right, so that hasn't resulted in the acquisition of the shares yet.
No.
Or might never do.
And if the consents are refused, it doesn't. But you say that that is an exercise of the option.
Well, I think that must be right on the meaning here.
So it's not inherent in the exercise of the option that JPM does acquire the shares. There are circumstances in which the option has been exercised, but yet the shares have not been acquired.
Yes, I mean that would be
Or not yet acquired.
not yet acquired.
Or not acquired at all if the consents are refused. I think you just accepted. If the consents are refused, the option's still been exercised.
It's a binding. What happens is a binding obligation results, and then the parties enter into the process in 4.2. So they have to enter into the transfer agreement. The transfer agreement has conditions precedent, one of which will be, in the usual way of a transfer agreement, one of which will be obtaining the necessary regulatory consents. And of course it's possible that the conditions precedent in the commercial agreement for sale are not met. So that
That's the point I'm putting to you.
Yeah.
On the argument you've just been advancing, JPM may be said to have exercised the option on the true construction of this schedule, even if the exercise of that option does not result in JPM acquiring the shares.
Well, that's because if you look at the
mandatory consent,
you look at the first option period. So let's assume you well, it doesn't really matter. It's the first, second, and third really. You exercise the option, you send the option, you send the notice, and the offer that's made is accepted.
Yes.
Then you have to go through the 4.2 process,
Yep.
which actually gives you 12 months under 4.3.
I think it's,
And at the end of the 12 months, the mandatory consents are not forthcoming, and they're not going to be forthcoming. So the call option long stop date has arrived, at which point the whole thing comes crashing down, as I understand it. Where does that leave the option that has been, on your case, has been exercised because you've sent the notice and it's been accepted? Which I think is similar to the question my lord was asking.
I think the only answer must be that the option process is dead.
Sorry, the option process is
Dead. Because, but if you're not going to get the relevant consents that you need from the regulatory authorities to make this transfer, then it's always dead.
Yeah, okay.
Depends what they are actually, I mean, you might not get them at some point. You might at a later.
Well,
Yeah. Can I just, it might be helpful just to look at the definition of mandatory consent. It's
yeah, I
on
was
page
just looking at that.
602, thank you.
Any approval or non-objection is required under applicable law. Without which a transfer of shareholder instruments would be or could reasonably be expected to be a breach of applicable law. So it's effectively a situation in which, however much you want to buy the shares, for some reason you're not entitled to.
Yeah.
Or it's reasonably anticipated.
And most commercial sale and purchase agreements for assets of this size are going to have that type of conditionality in them.
Yeah.
But you say that, anyway, but going back, you say where I came into this, that exercised on the multi-shot interpretation doesn't require completion. It's just, as it were, election to exercise plus acceptance.
Well, it's exercise plus acceptance, which, as it were, stops the clock running.
Yes.
And then you move on to the
that
next
process.
stage, and the next stage
Yes.
is 4.2 and the completion process.
Exactly.
But if you get to election to exercise plus acceptance, and then it all falls over because no mandatory consents are obtained, then the whole option setup has gone.
Yes, I think that must be right.
Being frustrated.
And even though the mandatory consents might at some point later on have been obtainable, depending on what they were, it doesn't matter if this is gone.
Well, the parties could always agree
Well, yeah.
to extend that to the transfer agreement, but yeah, that must be right.
But JPM have exercised the option at that point. So in the next option period, WRL can exercise its option.
No.
No, sorry, it's the other way around.
because provided neither,
Other way around.
JPM's exercised its option because it's been accepted.
yes,
As I said to you a moment ago, that just basically stops the whole of this.
the whole thing.
The whole of this comes to an end and is replaced by the transfer provisions in 4.2 and other places.
Yes.
And as you say, if you can't get the mandatory consents, and subject to the parties agreeing an amendment, it's just the whole thing comes crashing down.
Yes, and then so the proviso puts that beyond doubt. Even though there's another, on the face of the contract, there is another option exercise period which is defined in temporal terms. You don't get to it because of the proviso. So I mean that's a very long answer to
Well, there's another,
to
just
the
sort of
question.
thinking aloud, and tell me if this is just nonsense, but another reason why you may be right about multi-shots is that the 3.2.3, sorry, the option exercise periods are 6 months apart. So if as you say, exercising not being previously exercised means sending the option notice and it's been accepted, so the clock stopped running. That's necessary, that construction is consistent with the fact you have 12 months for all the various other things that have to be done in order for the transfer to be effective. So it's basically saying during the 12-month period, you stop the clock running for the next 6 months. So what you can't have is somebody saying, oh well, you haven't exercised the option because even though I accepted it,
I haven't got the
you
shares
haven't
yet.
got the transfer through.
Yeah.
Sorry, that wasn't very coherent, but I think you follow what I mean.
I think it might be more than 12 months, because if you look at 4.2 again,
Yeah.
I think page 531, the 12 months is the date from entry into the transfer agreement.
Yes.
So you may have longer.
Yeah, maybe longer. Yeah.
Can I just, I'm about to do something which is never advisable, which is to think out loud. So this may be, this may not, but I'm just a bit confused. Can I just run through? Let's assume that there's a JPM exercise, send us a notice, let's say during the first option period, commencing on the first option exercise date, so we're in 2.3a, yep. And that is accepted. But we then get to a stage, so you'd say that amounts to exercise of the option, the JPM option, in accordance with these provisions. But then we get to a situation where the contract can't be completed because the mandatory consents aren't obtained. And I think you said everything would fall over. Is that right? The only reason I ask that is because the WRL option kicks in, is this right, with essentially you look to see under
2.9.
2.9.
Yeah.
It says it can exercise the call option commencing on the relevant WRL option exercise date. And by sending the WRL exercise notice. So let's assume we get round to the next option period, i.e. the second one. The WRL exercise date is 31 days after the JPM second option exercise date, and that's just given as a date, so many days after a certain measurement date. I don't think that's dependent on anything, it's just the date, isn't it?
Yeah.
And then it says if JPM doesn't elect to exercise the JPM call option in accordance with paragraph 2.3b, well, it wouldn't have done because its option's gone. Then why can't WRL just exercise its option? Because under 2.9, because JPM would not have exercised its call option in the relevant option exercise period. So WRL can go ahead and exercise its option, can't it? I did preface my remarks by saying this was. I'm struggling at the moment to your answer was everything falls over and that's an end of the story. We'll go ahead. But I'm just wondering, with these definitions, I'm just wondering why that would be the case.
I mean, I think the answer is, and again, I should preface my answer with the same caution, but I think the answer is that provision assumes that JPM has a call option to exercise in the relevant period. And if you look back at the definition of WRL option exercise date,
yeah, you're saying, are you saying that the definition of WRL option exercise date presupposes that there was
Yes.
a JPM call option that could
Could have been
Yes.
exercised.
could have been exercised, and so the fact it just says you didn't,
Yeah.
It does not, it doesn't elect to exercise the JPM call option. In one sense, it doesn't, but the reason why it doesn't is because it's already exercised it in the previous period and it's been accepted.
yeah, but
So it would be pretty odd if you could come along having the option notice having been accepted in the first period, but the sort of nuts and bolts not having yet been gone through.
Yeah.
If WRL could come along in the second option period and say, even though you exercised the option and we accepted it,
yeah, I agree, but that actually wasn't the example I was thinking of. The example I was thinking of is where JPM exercises the option, it's accepted, the contract's entered into, and then they go off for mandatory consents, and the regulator, whatever it is, just comes back and says, over my dead body, JPM, no way. Therefore, JPM's option is gone, because the mandatory consents are not. And then are the parties just stuck? Or is the way that this will be broken is by WRL, I mean, that's no disrespect to JPM, obviously, in that, but are the parties just, is the way out of that impasse that in fact WRL can in those circumstances say, well, we know that the JPM option was exercised, but it's never going to be capable of fulfilment. So we now, have the right to step in and break the impasse the other way around. And so I mean, I don't know. I mean, it's just people might want to just think about it, but it's.
Yeah.
I mean, at some point you're going to come on to commercial common sense.
Yeah, well,
and
that's
where this comes in. I think.
Exactly, because I think the court has our point that at that point there is no flaw to protect JPM from the mandatory exercise of the option to acquire its shares. So we do say that offends business common sense.
Well, in a sense, why would it?
Well, JPM has made an investment in this company of 900 million euros, and the option periods are structured in the way that they are, with JPM going first, WRL going second. Careful mechanism to protect WRL in terms of not having to sell at too low a price, but nothing on one shot to protect JPM at all.
well, there might be a, sort of picking up on my lord's point, there might be an answer to the conundrum, if I can put it that way, to be found in 214. And it's 214, option completion date. The completion, and then 4.3, which is option completion date shall be no later than the date, which is 12 months from the date of entry into the transfer agreement. So that's contemplating you might take 12 months. It's the same 12 months as is in relation to the mandatory consents. Long stop. So if during the 12 months following the transfer agreement being entered into, the mandatory consents don't come forward, then that clause, 4.3, suggests that option completion doesn't take place.
Yeah.
It can't take place unless it's agreed to extend in some way. In which case it might be said, well, you go back to square one. And WRL could exercise its call option.
Yeah, I wasn't certainly. Your answer was, well, one shot doesn't have a protective flaw for JPM. Don't I understand you say that? But actually, I was working with your version of what exercise
Yes.
means. And I was just trying to understand whether in fact it's the case that even on your interpretation of exercise, it's possible you get to a situation where there's no floor for WRL exercising its option.
Well, that would
I think
be,
I think you say, well, that can't be the case because the WRL option exercise date presupposes
yes,
there is a live JPM call option during the relevant period, and if there isn't, it doesn't exist, and that's your
yes,
that's your actual answer, I
yeah,
think.
that is, my lord, yes. And that, we get that from the definition of WRL option exercise date, because
Yeah, so it's not as complicated as I was suggesting. There just isn't as it were, a valid JPM
And you have
exercise, so none of that applies.
when you have to read in, you've got to read in something by implication, I think, to get to where you want to go. To that answer, you've got to say it's implicit in the definition of WRL exercise option exercise date that it reads JPM first option exercise date. Sorry, let's try the second one. JPM second option exercise date if JPM does not elect to exercise the JPM call option brackets on the assumption that one exists. Some such wording in accordance with.
I'm not sure you need to, well, I don't know whether you need to read that in explicitly, but if you do go back to the definition of WRL option exercise date, which is what this is talking about in 2.9, then that's defined, WRL option exercise date is defined as the date that is 31 days after the JPM first option exercise date. If JPM does not elect to exercise the call option in accordance with paragraph 2.3a. So it does, we say the right way to read that is that the JPM, the WRL option exercise date only really comes into being on the assumption that JPM still has a call option that it has or has not elected to exercise in accordance with 2.3a.
Yeah,
So,
not in a situation where it's exercised the call
And it's all
sent
over.
the notice and the notice has been accepted.
exactly.
Yeah, I mean, it must have a valid election during the date in order to bring that date into being, as it were. Yeah, okay, I understand. Sorry,
Yeah.
I'm sorry to have
Not at all.
diverted you out
That's very helpful.
on
Right, that's 2.3. I think the next clause relied on is 2.5, which is the clause dealing with the date. Oh, sorry, can I just before we leave 2.3, the or, and that was relied on by WRL as saying, well, you've only got one possibility of exercising, of sending your notice in any of those periods. We say that actually the or, all that's doing is denoting that JPM has a choice whether or not to exercise its option in each period.
you say that's consistent with the plural times.
Exactly,
Because otherwise you would say at only one of the following times.
exactly. So 2.5, we say this takes WRL no further, and what this clause is doing is essentially a deeming provision to give certainty about the date on which the call option is taken to have been validly exercised. And the judge described this in paragraph 335 of the judgment as it's about the mechanism of exercising the option and not intended to define what exercise actually means. Now, it's important in this contract because of the features that we've been discussing. It is important to have this deeming provision. And that's because there's situations, as we've seen, where JPM can't bring about a purchase of shares simply by sending the notice, and it's dependent on something else, like WRL accepting. So this deeming provision means that JPM will be taken to have exercised the option in time, in other words, before the window closes, provided it's done everything that it has to do, in other words, send the notice before the window closes. And that's necessary because otherwise JPM might be found to be out of time simply because of how long it takes WRL to accept. And you can see that there might be room for uncertainty about the effective date of the exercise, as it were, given the possible different outcomes. For example, WRL might accept on day 2 or day 4, or they might not respond at all within 10 business days, in which case 2.6 tells us that they are deemed to have accepted. So what this provision is doing is removing all of that uncertainty. But it doesn't mean that simply by sending the notice and nothing more, you have exercised the option for all purposes. And the same point applies to paragraph 2.12, which I think was mentioned by WRL. That, again, is dealing with the content of the option exercise notice. It's about mechanics. The judge dealt with this at paragraph 360. And as she said,
Paragraph?
360 on page 256. And what she said, we don't need to turn it up, because what she said was 2.12 goes hand in hand with 2.3 and the election to exercise. So 2.3 sets out the structure, and then 2.12 elaborates on what goes in your notice. 2.12 is not telling you what constitutes the exercise of an option, it's telling you what you put in your notice and how you kick the process off. So the word exercised in the first line of 2.12, that's one of the instances we say where you have to read that as elect to exercise.
Yeah.
Because it's essentially, as I say, referring back to the first line of 2.3. (2.6) and 2.7. Now, as the judge correctly observed, these paragraphs are not actually to do with what constitutes the exercise of an option, but they're to do with the circumstances in which WRL has the choice to accept or reject. And as Mr. Weeks said, and we agree, they come as a pair. So 2.6 is dealing with the first three option periods, 2.6 with the fourth, when WRL is automatically deemed to accept. And it was said on behalf of WRL that 2.6 helps them because it draws a distinction between exercising and accepting the option, but that's not actually what it says. It doesn't use the word exercise. It simply draws a distinction between sending a JPM exercise notice and acceptance, deemed acceptance, and so that's actually consistent with JPM's case. And there are two further points in favour of multi-shot. Firstly, as the judge rightly said, the reference to a JPM exercise notice in the fourth line of the Chapeau 2.6 is not consistent with one shot, because if JPM only had one shot, it would say the JPM exercise notice, not the largest point. But the second point is perhaps more significant. Subparagraph A deals with the situation where WRL is not obliged to accept the option because we're below 5 billion in the valuation and we're not in the fourth option period. Now, the part in brackets that begins provided that deals with the situation where WRL rejects the JPM call option. It sends a notice. And if you pick it up from the words "for the avoidance of doubt," 2 lines from the end, it says, for the avoidance of doubt, if WRL issues such a notice, that's to say a rejection notice, the parties shall proceed to the next option exercise date. Now, this is a similar point to the one that was anticipated in relation to the diagram. If one shot were correct, then the only relevant option exercise date at that point would be the WRL option exercise date, and that's a defined term.
Well, option exercise date is a defined term which includes all the JPM exercise option dates, option exercise dates, and the WRL option exercise date.
Yeah.
So I mean, you might be said that this is you shall proceed to the next option exercise date means the next time anybody can exercise an option, but what it is contemplating is that, depending on the circumstances, both parties have the right to exercise the option.
Yeah, it's only consistent.
It would have said, shall proceed to the next WRL exercise option.
Exactly. The use of that defined term, meaning both parties, is only consistent with multi-shot. And that was the point made by the judge at paragraph 341.
And that's also suggests, does it not, that the reference to option exercise date in the diagram means both.
It's the same point. .7, the second one of the pair. Now WRL focus on the first line and the use of the word exercise in the first line, and they say, well, that is drawing a distinction between sending a notice and its consequences. Now, this is one of those instances, my lords, where we do have to read exercise as elect to exercise. But the reason why it's clear, we say, that we get from the first two lines of 2.6. So both of these clauses are talking about what happens after you've sent a notice. If we go back to 2.6, it says, save with respect to any JPM exercise notice served after the JPM fourth option exercise date, in accordance with paragraph 2.3d, for which paragraph 2.7 applies. So it sends you then that the opening words of 2.6 really introduce clause 2.7, which is concerned with the fourth option period. So there's a link between the two paragraphs, as we know, and then when you get to 2.7, that's concerned with essentially the same thing as 2.6. In other words, what happens after JPM elects to exercise the option by sending the notice.
Could you just explain what's the emphasis you put on elect to exercise? Elect to do something is to choose to do it.
Yes.
But in either case, what you're choosing to do is to exercise the option.
Yes, I'm using it because that's the phrase that's at the beginning of 2.3.
Yes.
But I'm using that as the way I put it at the beginning was that because the way that this option is set up in the first three option periods, the most that JPM can do is send a notice. And then
that's nothing to do with the word election.
Well, it's choosing to exercise in the sense of beginning the process by sending.
Yes, that depends on what exercise means. So I don't at the moment understand what extra you get to attributing a meaning to the word exercise in these various paragraphs we're looking at by fastening on elect to exercise, which isn't actually what the paragraphs say. I don't see what point you're making here.
I'm not using election in the sort of traditional legal sense of, it's just a way of denoting that this is the course it's going down.
Choose.
Yeah, choose, exactly.
Yeah. Well, the chapeau of 2.3 says may elect to exercise. So given that this is referring to 2.3d, and 2.6 is referring to all the other periods, I can see the argument for saying it's an election to exercise.
Yeah. But one shouldn't get too hung up on the word elect in a sort of true legal sense. Choose to exercise. And it doesn't say, 2.3 doesn't say JPM exercises the JPM call option.
No.
You say it chooses to, it starts to.
Yes, well, it has to say that because JPM is not compelled to do anything in any of the option periods. That's the nature of an option.
Yes.
So it chooses whether or not to do what 2.3 provides for.
Yeah.
I mean, it all depends on context, doesn't it?
Well, it does. Yes, it does. And this is an imperfectly drafted contract, as we have seen. But
I mean, if I say you can choose to come for a drink with me on Monday or Wednesday, I'm not really inviting you on both occasions. I'm giving you a choice between the two.
Neither.
Okay, yes.
As you say, it's not a very well worded contract in some respects.
No, and I come back to the point I made at the beginning, which is there isn't a single, one does have to pick and choose between these clauses, and it's not perfect. So I was on 2.7 and just linking, I think you'll just have the point, but I was linking the first line of 2.7 back to the first two lines of 2.6, which is talking about the service of a notice. So that was really neutralising the point made against me that exercise in 2.7 must mean send a notice. We agree, but you get the context from 2.6, which is simply talking about sending a notice. Doesn't mean you read exercise in that way for all purposes. Now, 2.9 we've looked at this already. So again, we don't shy away from the fact that in the second half of 2.9, the word exercised there does mean send a notice. And I hesitate to go back to elect to exercise, but it is common ground between the parties that the effect of 2.9 is that if JPM sends a notice, then that does block WRL from exercising
It
its
sends a
option.
notice that's accepted in one of the periods, or sends a notice in the relevant period.
Just sends a notice in the relevant period.
Yeah.
Now, there's an important point here on commercial common sense, my lords, because this was a point that really struck the judge. Now, the effect of 2.9 is that if JPM only has one shot and uses it by sending a notice that is then rejected, the effect of 2.9 in conjunction with the other clauses is that WRL then has to wait another 6 months before it can exercise its own option, because it can only exercise its option in a period in which JPM has not already done so. And not only does it have to wait 6 months for the next measurement date, it then has to go through a whole new valuation process. Then it has to sit on its hands for the 30-day JPM option exercise period, which on the one-shot construction is now entirely redundant because there's no longer a JPM option. And only then can it exercise its option. And we say, well, there's no commercial logic to that, because if JPM's chance is over at that point, once it's used it for one shot, why not allow WRL then immediately to exercise its own option and bring the whole process to an end? Why wait another 6 months and go through another valuation process? But on the multi-shot analysis, we say this does make sense because JPM has multiple opportunities to serve an option notice. WRL can reject in the first 3 periods if it's below the reference valuation, and then over the course of the various option periods, the 30-month runway, WRL can seek to grow the business and try and reach the €5 billion target. Now, the only answer WRL have come up with to that is that the 6 months might be useful for it to raise finance. And that was rightly rejected by the judge in paragraph 354, which we might just turn up to page 255. Paragraph 354, can I just ask you to read that?
So did you say 255?
Sorry, page 255, paragraph 354.
Yeah.
And so, as she noted there, you may end up going through a whole new valuation process and end up with a different valuation. So that may affect how much finance you need. But in any event, if having
Can we just go back to the definition of WRL option exercise
Yeah.
date? Page 523.
Mhm.
It's the date that's 31 days after the JPM first option exercise date. If JPM does not elect to exercise the JPM call option. So what do you say does not elect to exercise the JPM call option means in that definition?
it means doesn't send a notice.
Sending the notice.
Yes.
Because by definition, WRL wouldn't be seeking to exercise their option if they'd accepted the notice. So it can only be just the notice on its
Yeah.
own and
Yeah.
nothing else. Yeah.
So the other point about the argument that WRL made about needing 6 months to raise finance, if that were really an important commercial consideration, then they would need to provide for that in the first option period.
Yeah.
In case they needed it then. But, I mean, it isn't actually a commercial purpose, it's an explanation thought up after the event. So 4.2 is the last clause. We've already looked at this, but the short point about 4.2, page 531, is that actually this is a clause where neither party's construction can be applied throughout, because I think, as was observed earlier, the use of the word exercise in 4.2a must by definition, or from the context, must mean where a binding obligation to sell has resulted, because it's talking about moving into the next stage. So the use of the word exercise in A is talking about the obligation to sell having arisen.
Yeah.
So that's why the judge said, well, it's an imperfectly drafted clause, and but it doesn't actually work on Learned Friend's case either, because that exercise in 4.2a must mean what I say is the meaning in 2.3. So then just on the diagram, I've been working from the diagram at the back of the core bundle, but if your lordships prefer the multicoloured one, I can go back to that. It's page 263 of the supplementary bundle. Now, if you start with the bottom half of the diagram, this corresponds to the period after the options can be exercised. So it's been annotated helpfully with clause 15.1. You see the chunk of text under clause 15.1. So that's the clause that we've looked at. And we know, because I started with that you only enter this is dealing with the strategic review period. And we've seen you only enter the strategic review period when there has been a full exercise of the option. And then to the right of it, you see the post-lock-in period, that's Schedule 2 that I mentioned. And then working upwards from that, we move to the earlier stage of the process. So you can always put a sort of line over that bottom section. And we were discussing earlier what's been called the middle route through the diagram. And WRL say, well, that supports the one-shot argument. Because if you end up going through the middle route of the diagram, so if you start currently measuring a fourth measurement date, answer no, and then we're less than the reference valuation, answer no, so we're in the world where there is no automatic acceptance. JPM exercises the call option, yes. WRL agrees to sell, no. defer to next option exercise date, and your lordships have the point about that as a defined term. Now, WRL say, well, you then go along the dotted line and back to the beginning, as it were, and to the red box to the right of the blue box. And they say, well, why, if JPM has a call option remaining, why would you need to ask that question on the multi-shot argument? Because if that's correct, then JPM would always have a call option remaining. So there's a number of problems with this. First point is a basic one, which is that if the party's intention was that JPM was going to lose its option for all time simply by sending a notice, then that would have been made crystal clear. That would have been a highly significant consequence which would have been spelled out, but it is not. Second point you have is the reference to option exercise date rather than WRL option exercise date. And really, then looking at the key red box, as it were, we say that that can't bear the weight that WRL put on it. The first problem is there are two separate questions. So only having a binary route out, yes or no, makes it rather hard to understand. Now, WRL's answer to that is to ignore the first question and simply ask the second question. But the first question is problematic for one shot, because if you just ask, are you prior to the fourth measurement date, and then answer the question no and go down the down arrow, that leads you immediately into WRL exercising its option. But of course, you could be in the fourth option period, actually on either party's construction, with JPM still having an option to exercise. But on the one-shot construction, for example, where JPM has saved up its one shot for the fourth period. So you could answer no to the question, am I prior to the fourth measurement date? And then you would be down into whether WRL can exercise its option. And that makes no sense because JPM would still have one remaining even on one shot. So unless that's why WRL want to ignore the first question. But we say that actually the key to understanding that part of the diagram, that box, is where the no branch takes you. Because ultimately, as I started, the no branch takes you straight into the strategic review period if WRL don't exercise their option. And we say, and the judge accepted this, that the obvious way to understand this red box is that it's simply a shorthand for asking whether the parties have got to the end of the option process in the last period, so that the only routes out are for WRL to exercise its option, or if it doesn't, then the parties end up in the strategic review period.
And that, unless I may have missed it when you were saying, is that consistent with the box if you answer yes, which says currently measuring at fourth measurement date? Remember, earlier on we said it's a bit weird.
Yeah.
That if this document was supposed to be an example that was applicable throughout all four option periods, and you read the red boxes being answered at the end of, so at the start of, say, the second option period, you wouldn't be able to answer the question that is then posed if you answer yes to that. You're saying this only applies actually at the fourth option period, which is why the question you then get asked, if you go up, yes, currently measuring at fourth measurement date, is actually capable of being answered.
Yes.
Sorry, that's very unclear. Sorry.
Yes, well, it is very difficult to understand, and
But so that's consistent with your argument, I think, that
yes.
you're just putting. What does measuring mean, just out of interest? What does currently measuring mean?
Well, I think it's a reference to the beginning of the evaluation process, the measurement date, probably.
So I know what the measurement date. I know what the measurement date is.
Yeah.
But but what does measuring mean? Currently measuring. What does it mean? You know, it's not like somebody with a tape measure or something. What's going on?
No, presumably not. I think it just means that you've hit that. You just could say
That's when you're looking at the.
Yeah.
Well, let me turn the question round. How would you not be currently measuring at the fourth measurement date? Because there's a no option. What does it mean?
Well, the no option is meant to cater for the scenario when you're in the first three option periods and WRL can refuse. That leads you to the middle.
No. If you answer the question, as I understand it, sorry, let me just get this with the colour up on the screen, because otherwise I'm got a coloured one in front of me. Just get this. No, I've accidentally closed it down, I think, unfortunately. Anyway, the first question you get to is prior to fourth measurement date and JPM has a call option remaining. You say that's actually only dealing with the fourth option period. That's, I think, what you've just submitted.
Well,
So if you say currently measuring at fourth measurement date, answer no, that means you're measuring at some earlier date.
Yeah.
So then you've got JPM call option price greater than or equal to reference valuation. Yes, JPM exercise, JPM call option. Yes, and then you go to the next page. Or JPM call option price greater than or equal to reference valuation, answer no. And then JPM exercises JPM call option. And then the next one is WRL agrees to sell at call option fair market value. Now that one's only relevant if you're looking at a period before the fourth period.
And equally, if you're at the fourth period, there is no next option date to defer to.
No.
so you would keep
Which is
going.
why if you go currently measuring at fourth measurement date, answer yes, you then get into the whole issue of which party exercises its option. Because either JPM exercises the call option, in which case you move to the
To the next
transfer
page.
provisions, or it doesn't, in which case you move to point A.
Yes.
And point A is all about WRL exercising its option, in which case you go to the next page. Alternatively, you get into Schedule 2.
Yes. I mean, another way to have done this diagram would have been to, I don't know if this may not help, but one way I've thought about it is you could put a circle around all of the bit that I started with from point A and move it to the bit where it says move to point A. That may not be helpful, but the point that I was going to make is that the box, just focusing on the no arrow for now, because that is really where the problem is with the one-shot construction. Because WRL say, well, you just ask the question in the red box, you ignore the first question, you just ask, does JPM have a call option remaining? But just imagine for a moment, we've gone through the diagram in the way that we just did. So we've ended up at the middle defer to next option date in option exercise date in brown writing. So in other words, JPM has used its one shot, WRL have rejected it, and we're told to go to the next option date. We then go through the blue box and we ask, does JPM have a call option remaining? To which on one shot the answer is no. We then go to WRL exercises the call option, and if they don't, we end up in the strategic review period. But we've seen from clause 15 that that's what I started with, you only end up in the strategic review period in circumstance where neither party has exercised its option or there is some other reason why one party holds all the shares. So that just doesn't work. So the one-shot reading of the diagram, if I can call it that, is inconsistent with the words of clause 15 that you weren't taken to. But if you read the diagram as we say you should, and as the judge did, so you read that red box as essentially shorthand for, is there any opportunity left for JPM to exercise its option in the sense of, well, has it run out of road? If not, then the only possibilities out are WRL exercises its option, or we get into the strategic review period and the post-lock-in period and so on. And it's paragraphs 377 to 383 of the judgment.
So you say what, prior to the fourth measurement date, what that box is really saying is asking the question whether the JPM has exercised served an exercise notice in that option exercise period, is that right? Because if the answer is no, then you go to the WRL can exercise its option. If the answer is yes, then you go to the rest of the diagram. Because what the curiosity is that it's asking about the prior to the fourth measurement period, and then this curious thing about currently measuring at the fourth measurement period.
But I think that the way to read currently measuring at the fourth measurement date is to determine which branch you then go down. So if the answer is no, if the answer is yes, then you immediately end up on page 2.
Yeah.
But if the answer is no, then it means you're still within the conditional period, if we can call it that, and you go down the middle road. But the red box is doing something else.
Yeah.
If you look at the way the judge put it, because we do endorse this, it's page 258 of the bundle. And it's really pages 377 to 383. It's late in the day, and I know that your lordships have read the judgment, but that's the analysis that I've just been through.
Sorry, give me the reference again.
I'm so sorry. It's paragraph 377 through to 383, and that's dealing with that point about the red box. And the point that I made about clause 15 is in 380.
Yeah.
So in a way, you can read the red box by sort of working backwards. You look at the bottom of the diagram, and the bottom of the diagram takes you into the strategic review period, the post-lock-in period, and so on. And then the only other point, my lords, is in relation to the second page of the diagram. I'm afraid we need to go back to the core bundle. Just one short point to end with. It's the very last page of the core bundle. And this is relied on, I think it's the blue box is relied on by WRL as saying, well, that's only consistent with one shot because it refers to JPM exercising the call option, WRL agreeing to sell. But really all that box is trying to do is to capture, if you go back to the previous page, 617, it's really trying to capture all of the blue ovals which say see next page. So there are lots of circumstances in which you can end up on the next page, one of which is WRL agrees to sell, but actually even that doesn't encapsulate all of the circumstances in which you would end up on the second page. So for example, if the reference valuation is over 5 billion, then you would end up on the second page even if WRL hasn't agreed to sell, or if you're in the fourth option period. So it just means you've ended up at this stage of the process. There's no particular magic in the word, in the wording in that box. And I haven't dealt with commercial common sense. That's in the judgment at paragraphs 395 to 401. And firstly, as to the question whether we get there, you've got my point about the way the parties were proceeding on the basis of the multi-shot construction being correct. Now, I'm not going to go to it given the time, but the reference is Mr. East's evidence at page 408 of the core bundle, and that was the evidence served at the Part 8 claim, which is where he describes the exercise of the option. That was served in February when the proceedings were issued, before anyone had thought of the one-shot argument. And that, it's the paragraphs I particularly rely on, the 10.2, 10.3 and 11. If you perhaps look at 11, this is where they make their perverse incentives argument about the operation of the option. They say, well, there are perverse incentives for JPM to depress the value of Viva. Now, that can only be right on the multi-shot construction because it implies that JPM has the right to block the exercise of WRL in every option exercise period. So it is clear that that was the basis on which people were proceeding. So this is therefore a very different case from Palladian, where, as I'm sure my Lord Justice Lewison knows, the court there found that the words, the construction that the Republic were arguing for there was irreconcilable with the actual words of the agreement. So
If we're looking at commercial common sense at this stage,
yeah.
Your interpretation in effect means that JPM must serve a notice in each option period to block WRL, even if it doesn't want to acquire the shares.
Yeah, yes, unless, and that's right, unless it is happy.
That doesn't make a lot
Well,
of sense.
unless it is happy to sell, because at that point they'll know what the valuation is. If it decides it doesn't want to buy, but it's happy to sell to WRL, then it wouldn't serve a notice. But if it doesn't want to buy, if it doesn't want to sell, then yes.
If who doesn't want to sell?
If JPM doesn't want to sell, then yes, it would serve a notice. But there's just a binary choice there each time. Do I want to buy at this price, or do I want to take the risk that I will have to sell at this price? But just very briefly on commercial common sense, what the judge found was that if the one-shot argument is correct, then it's not really, what JPM has is not really an option at all. I mean, perhaps this is the converse of the point that was made earlier about labelling. The JPM option is really just a one-off blocking right that it can only use once, and then it is, as I've said, exposed to the possibility that it will have to sell at any price without the protection of any floor valuation. And that, we say, is not what reasonable commercial parties would understand as an option. Excuse me a second.
Yeah.
Yes, the point is made from behind me that there may be still a purpose in sending a notice, in that JPM is indicating in each option period that it is willing to buy at that price, even if it's not accepted.
Well,
Yes, and
that may or may not be so. I mean, the point is that even if JPM is not willing to buy, on your interpretation, it's got to send the notice in order to stop WRL from exercising its option.
yeah, that's right.
JPM would actually much rather wait a couple of years before buying, seeing how the business goes, but nonetheless it's got to send these notices every option period just to stop WRL from exercising its own option.
Well, it's indicating that it's willing to buy at a price, and bear in mind that there's a 30-month period over which these options can be exercised, and the 5 billion figure is the figure that WRL said it wanted. Mr. Coronis said he wanted for the business. So it has the opportunity to grow that over the period. At each option period, 6 monthly intervals, JPM can indicate that it's willing to buy, even if the notice is not accepted. It then, I mean, it may be just doing that to block WRL, but also it is keeping the option alive until a time at which WRL are prepared to sell, or you reach the valuation, or you get to the end of the runway. So, well, unless I can assist, those are my submissions.
Thank you.
My Lord, briefly, in reply, in the order that my learned friend helpfully took her points, she referred to clauses 15.1 and 14 and observed that they would involve a use of the term exercise, which wasn't, if I may summarise, the same as sending of an option exercise notice. And I think I acknowledged that point in my own opening, in which I said that in Schedule 1, term exercise can be read consistently with each other all the way through Schedule 1 if the one-shot construction is correct, but the multi-shot construction cannot. So I accept that there would be an inconsistency vis-a-vis clauses 15 and 14.1, but not that there's any inconsistency within Schedule 1 itself. And my learned friend accepts, as she accepted below, and as the judge found, that there is inconsistency in how the term exercise is used if the multi-shot construction would be correct within Schedule 1 itself. We do refer for some assistance to the interpretation section in the SHA. The relevant clause is to be found on page 611. It's clause 2.1. And if one turns over to page 612, there is subparagraph H. Subparagraph H provides that there's any consistency between a definition set out in this schedule and a definition set out in any clause or any other schedule, then for the purposes of construing that clause or schedule, the definition set out in that clause or schedule shall prevail. Now, we're not dealing with an inconsistency between Schedule 16 and elsewhere, but what we do say is that points to the approach of the draftspeople, which is that if there is inconsistency, one proceeds on the basis of the definition in the schedule and not the definition in the main body of the agreement. And that's the approach that we take in that regard. In paragraph 2.3, we made the point in opening, and we reiterate, paragraph 2.3 is the essential provision. There is no obvious reason why JP Morgan, having exercised the right to buy the shares, would be considering exercising the same call option again to buy the shares it has just bought if the multi-shot construction were correct. It's not concerned with the WRL call option only, it's also concerned with the JP Morgan call option. In relation to paragraph 2.5, paragraph 2.5 is the paragraph that is concerned with the date of exercise of the call option. The date of the exercise of the JPM call option is the date on which the JPM exercise notice is sent in accordance with paragraphs 2.3 and 2.12. My learned friend said that this was a deeming provision because things may take some time. Well, I think I made the point in opening that if it were to be a deeming provision, one would have expected the draftspeople to have said so. Instead, what they have is a clause 2.5, which is entirely consistent with 2.3 and 2.12. And in 2.3 and 2.12 and 2.5, they're talking about the call option being exercised by sending of the written exercise notice. If it were to be that the call option were to be exercised upon agreement or upon the consequence, as my learned friend said, upon a binding agreement to purchase the shares, one would have expected it to have said that in 2.3, 2.5 and or 2.12. One would have expected that to have been said in 2.5. And certainly if 2.5 were just intended to be a deeming provision, it would have said the date of the exercise of the JPM call option is deemed to be the date on which the JPM option exercise notice is sent. In paragraph 2.6, my learned friend made the point that the word exercise does not appear in the chapeau to 2.6. That's correct, we accept that. But my learned friend also fairly, and we say rightly, accepted that 2.6 has to be read together with 2.7, because 2.6 and 2.7 are dealing with the situation in which JP Morgan sends this exercise notice and what happens then. 2.6 deals with the first 3 option exercise periods, 2.7 deals with the 4th option exercise period. It is that which means that it is important that the language chosen at the beginning of clause 2.7 is if the JPM call option is exercised. If the JPM call option is exercised is synonymous with the sending of the exercise notice, which is the beginning of paragraph 2.6. In relation to paragraph 2.7, of course, my learned friend also accepted, as she must, that if the JPM call option is exercised means the sending of the option exercise notice because of the distinction between the sending of the notice, the exercise, and the deemed acceptance. If that is right, the same must also apply to paragraph 2.6. Ergo, we say that in 2.6 and 2.7, the clauses in Schedule 1 dealing with acceptance of the option, the JPM call option, the position is that the word exercise has to be read differently, and the distinction between sending the exercise notice and acceptance has to be read out in order for the JPM multi-shot construction to work. We also note in passing that the language chosen by the parties is the JPM exercise notice. It's not referring to a JPM call option notice, it's not referring to some sort of trigger notice, not referring to some sort of election notice. They have chosen to label this as actually the exercise of the call option, which is consistent with paragraphs 2.3, 2.5 and 2.12. In relation to paragraph 2.9, which is dealing with the WRL option exercise period, my learned friend made the point that it is submitted by JP Morgan that there is no commercial sense in there being a 6-month delay before WRL can exercise its option. Now, as we made clear below, the difficulty here is that the parties were not in a position to adduce any factual evidence in relation to the drafting of this agreement. As my learned friend observes, the issue in relation to the multi-shot, one-shot construction arose at a late stage anyway after the evidence was filed. It may even be the case, of course, that evidence as to what the party's intention was wouldn't be admissible anyway. I'm not in a position, just as I wasn't...
It's just an application to rectify.
Well, indeed, my lord, and I'm not in a position to give evidence as to what the commercial rationale would be. One can postulate different commercial rationales as potential commercial rationales to the extent that that is of assistance.
Well, I think there's a risk that with commercial common sense that whichever way you look at it, it might be said it makes sense for one party but not for the other, and you can switch the thing around and say, well, it makes
Indeed.
sense for WRL but doesn't make sense for JPM. And
Indeed, my lord. And on this.
Just to, I mean, we've got to be careful what we mean by business common sense. I mean, the exercise we've been going through of trying to understand what the commercial consequences of different meanings or different interpretations is entirely what you are supposed to do.
Yes.
different.
And there's nothing wrong with trying to understand as well what the commerciality of the consequences is.
Well, my lord, the dividing line, we would say, is the rationale. So what the learned judge held below, and it's a point that my learned friend relies upon, is to say, there's no commercial rationale for a 6-month delay that WRL would wish to exercise immediately. And we say that speculating as to what a party's commercial rationale would be or wouldn't be is precisely what Lord Justice Popplewell, distilling much learning in the Palladian case, observed is that the court shouldn't be doing, because the court can generally proceed on the basis that sophisticated commercial parties will have a commercial rationale or economic rationale for what they're doing.
Well,
And so
I think you've actually got to go back to what the Napier Park case, and I do this with a little trepidation, but that he was referring to for that, because there, my Lord, Lord Justice Lewison sort of made the point that you do take account of commercial consequences when performing an iterative process. You don't just bring them in as a sort of at the end, and the paragraph 37 that was lifted out does say that it says, on the other hand, where the iterative process of interpretation as described above, and that's all the iterative looking at commercial consequences, produces a clear answer, then the court must be wary of assuming that it knows what is or is not commercially sensible. So, I mean, I think you have to go through this iterative process, don't you, of testing what consequences are commercial or uncommercial, and trying to understand what the commercial rationale of the parties might have been in those consequences, just to see whether it's commercially sensible as part of that iterative process.
My Lord, we don't disagree with the proposition that one should go through iteratively and work out what potential commercial consequences are. Where we say the forbidden territory is then the court speculating as to whether or not that consequence is one which wouldn't have a commercial rationale. So here it is being said, as the learned judge held below, there would be no commercial rationale in there being a gap between WRL being able to exercise its option, a 6-month gap. And the judge says, I can't find any commercial rationale for that, if I may paraphrase. We would respond to that. It's a little bit difficult for us in circumstances where we couldn't produce evidence in that regard. What I could do below is postulate possible commercial rationales, one of which is there is a fundamental difference between WRL and JPM in this context.
Well, I think really what your point comes down to is there's a difference between the court saying, I can't see what the commercial rationale is for this provision on the one hand, and concluding there is no commercial rationale for this on the other.
Indeed. We respectfully endorse that, and that's what we were referring to in that dictum from Lord Justice Popplewell at paragraph 59, where the parties can usually be assumed to have intended the result and therefore ex hypothesi not to be regarded as one which has no commercial or economic rational. Now, I appreciate
but that's that's only where there is a clear answer from the process.
my Lord, my Lord, without wishing to dance on the head of a pin at 4:20, what we would say is the language the judge used was where the parties have chosen clear language in which to express their bargain. And we say that here clear language has been used. 2.3, 2.5 and 2.12 are clear language used to express their bargain as to what the sending of the exercise notice means. It means the exercise of the call option. And we say at that point, then it is territory which the court should tread very warily, if at all, concerning whether or not there might be an economic rationale. As I said, that's our primary position. We say that we don't have to identify one, but if it were necessary to do so, a possible, and I stress possible, I'm not giving evidence, I didn't give evidence below, a possible commercial rationale is that WRL is able then to say, I can be the buyer in 6 months' time because I can't be pushed back by JP Morgan. I have the sole right to buy these shares. That would enable WRL in that scenario to raise finance. It would also allow WRL a 6-month period in order to decide whether or not it wishes to be the buyer or not. So it's easy to identify two possible commercial rationales, and we'd say that the judge, with respect, fell into error in concluding that it could support the multi-shot construction, that there was, in her view, no commercial rationale. In relation to the diagram, my learned friend said that the key box ultimately has to be read as meaning has JP Morgan run out of road. Now, we respectfully disagree. The box should be read for what it is. It has got an important question. Does JPM have a call option remaining? Now, whether or not that causes difficulty with its relationship to the first part of the clause prior to the fourth measurement date and the next question currently measuring at the fourth measurement date still doesn't answer the fundamental question, which is why would the parties include that as the first question that has to be asked in the diagram if the correct position is that JP Morgan, as per 2.3 on the multi-shot construction, is entitled to exercise its call option at every exercise period, unless WRL has already bought the shares, in which case we're not in a valuation exercise at all, and we never get out of the blue box. The purposive construction has JPM run out of road, with respect is by the by. It doesn't answer the fundamental question, which is why would the parties have included that question, has JPM got a call option remaining, unless they'd contemplated the possibility that JPM could have lost its call option, and the way in which it would have done so is by sending an option exercise notice, which was then rejected. My learned friend made the point, we acknowledged it, and it was raised by my lords in my opening about the term next option exercise date, and my Lord Chancellor observed that it should have said WRL option exercise date. Well,
Yeah.
the construction still works on that footing, and there are other examples that one can identify within Schedule 1 where more precise terminology could have been used rather than the one which has to be chosen as applicable, not least in paragraph 2.3 itself. 2.3 itself, which is on page 524, it refers A, B, C, D and E to the option exercise period, whereas it should refer, to be technically correct, to the JPM option exercise period rather than the one that includes both, which is the option exercise period. So we say it is a very minor point, and certainly it would not be the horseshoe nail that caused the kingdom of the one-shot construction to be lost. It is a minor point. It works. It may have been improved by drafting, by referring to the
Well, your strongest point on the diagram has to be that the second box prior to fourth measurement date and JPM has a call option remaining.
Yes.
Doesn't make much sense if on the multi-shot analysis, because it's always got a, prior to the fourth measurement date,
Indeed.
it's always got a call
Indeed.
option remaining, by definition.
Indeed, my lord. Indeed. And we say,
Call option, picking up on the point that Ms Phelps made about the indefinite article rather than the definite article.
well, we respectfully agree, and that's why we say this is one of those cases, perhaps rare that they are, but this one is one of those cases in which the scales perhaps fall from one's eyes when one looks at the diagram. And that's why we say the key to it is the diagram, and it is confirmed by the box on the second page, which refers to after JPM exercise, JPM call option, or WRL exercise, WRL call option. And in the case of JPM exercise and JPM call option, WRL agrees to sell. Again, another question asked on the diagram, which cannot be reconciled with the multi-shot construction.
No.
My lords, may I just turn my back? Well, my lords, that concludes my submissions, unless you have any other questions for me.
Right,
My
thank
lords,
you
may
very
I thank the court and your staff very much for sitting both so late and allowing us an extra half a day. I appreciate that I've probably taken up a substantial proportion of the extra time, so I'm very grateful.
Well, thank you all very much. In Mr. Lissak's absence, you'll have to thank him on our behalf. Thank you all very much for your excellent submissions. You've given us plenty to think about. We're not going to deliver judgment extempore, you'll be pleased to hear. But we will obviously consider our judgments and that you have a draft as soon as possible in the new year. But again, making no promises. When you get the draft, it's only for typographical and similar corrections, not for inviting the court to reconsider its analysis. And please pay attention to the terms of the embargo at the top of the draft judgment. And so it only remains for me to wish everybody in court a very happy holiday period, and I hope everybody gets a bit of a rest.
Thank you.
All those in favour?